Welcome once again to Lehto's Law. Here's Steve Lehto.
Several people sent me the story from thedrive.com, including Cliff, and the story is written by Steph Schrader, who wrote at Jalopnik a while back. I did too, so that's where the name rings a bell for me. But Ford sues a bunch of Canadians over a GT supercar flipping scheme. And you may recall a couple years ago, I think I even did a video about it. John Cena, the wrestler, got one of these Ford GTs and was alleged to have sold it before he should have. And in case you didn't know, these cars are in such hot demand that Ford can pretty much name their own price and their own terms when it comes to selling the car. A friend of mine just got told he's going to get one of these cars. He applied and apparently made the cut. So when that happens, I'll go for a ride and I'll bring you along. But Ford accused a group of conspirators of reselling the car twice within weeks of getting it. And this is going on in Canada. So Ford's filed a lawsuit against a Canadian Ford GT buyer and a group of people that they claim worked with him in a scheme to flip the car for profit. And Automotive News has also reported the story. According to Ford, that 2018 GT didn't stay in Canada for long, as it was resold within weeks of delivery to a buyer in Europe, eventually making its way to a final buyer in Hong Kong. And that means, of course, this GT is just globe-trotting. But here's the problem. Ford's GT goes through a specific sales process different than the process you and I go through when we buy a Ford Explorer. Just getting on the GT's would-be owner's list was quite an ordeal. Ford handpicked just 1,350 people to buy a GT, and this is a list heavily loaded with influencers, celebrities, John Cena, my friend, he's one or the other, a celebrity or an influencer, and others who Ford felt would be able to broadcast the coolness of the car to as many people as possible. And of course, the car cost $450,000. Now, here's the thing. The car is worth $450,000. You buy it, you've got it. There are people out there who would approach you and say, I'll buy that car from you right now for more than you paid for it. You go, hey, it sounds like a great deal. Well, the problem is that Ford didn't want that to happen, because Ford could have gotten more for the car if they wanted to also. But they instead thought, well, let's limit it at $450,000 and just make sure it goes to the right people. And so they ask you to sign a contract when you buy the car saying, I'm going to hang on to the car for a specific period of time. So to prevent those 1,350 people from making a quick buck reselling the cars, Ford put a no flipping clause in the sales contract. And of course, that is a contract. So we'll talk about the contract because I am a lawyer and there's a legal aspect to this. Buyers were prohibited from reselling the Ford GT for 2 years after they took delivery. Now remember, John Cena did this, was alleged to have done this, and he eventually settled with Ford because Ford and he got involved in litigation. Now, another one of those handpicked buyers has gotten on Ford's blacklist. Stephen Hudson, the former CEO of both Element Financial Corp and vehicle servicing firm Engineered Automotive. According to court documents cited by Automotive News, Ford claims that they negotiated with Hudson through a co-plaintiff in this lawsuit, Downtown Ford in Toronto. Hudson never finalized the deal, but rather a holding company allegedly held by Hudson's ex-business associate and now co-defendant Bradley Nullmeyer did. Nullmeyer was the former CEO of Element Fleet Management Corp in Toronto, a company connected to Hudson's former company, Element Financial Corp. Ford says it did not know that Hudson had no ownership stake in the holding company during their negotiation, and this allowed the holding company to purchase the car. Making this even more confusing, Hudson claims he didn't know that Nullmeyer's holding company was purchasing this Ford GT in his name. So it gets weird. Mr. Hudson is now aware someone else used his name without authorization, Hudson's lawyer, Chris Pagliari, told Automotive News. When Ford brought this purchase to his attention, Mr. Hudson cooperated fully in the process, provided proof he had no involvement in the initial purchase, nor any subsequent sales transactions. That being said, Nullmeyer allegedly stored the Ford GT at Hudson's current company, Engineered Automotive, for about a month. Engineered Automotive's court filing denies being party to any conspiracy in the sale of the GT. Just 20 days after the sale, all of the shares in the holding company were sold to Timothy Quaxister, who serves as the president of Silver Arrow Cars in Victoria, BC, a high-end auto dealership which primarily sells to overseas buyers. An Ontario-based vehicle broker, Jeffrey Siegel, is alleged to have negotiated the holding company's sale for $94,000 commission from Quack-Sister. Siegel also is alleged to have received $148,000 U.S. from Nullmeyer, which was described by a judge as a secret commission in court documents. Siegel was accused of lying under oath about his interactions with the holding company in a court decision by Morgan, which Siegel denies. He has since been brought into this very convoluted legal action through a $1.1 million U.S. third-party claim by Quack-Sister. Siegel told Automotive News that he cannot discuss the case. Quack-Sister claims that he didn't know about the resale restriction, and Morgan and Siegel both blew holes in that argument, but it's confusing. Siegel testified that he discussed the no-flip rule with Quack-Sister, and Quack-Sister himself admitted that he received the confirmation order, which explicitly states the no-resale rule in a package of material from Siegel. So it gets very, very complicated, but Nullmeyer's lawyer told Ford's lawyer that he vehemently denies the allegations in the claim in a letter quoted by Automotive News. Likewise, Quack-Sister declined wrongdoing to Automotive News but would not discuss specifics in this case. Ford discovered that the car was for sale in Europe, according to documents that the Automotive News quoted. Morgan upheld a temporary injunction blocking the sale of the GT on November 13th, 2019, ahead of the trial for the lawsuit, which has not been scheduled yet as of this writing. Ford is now suing the group of people in the Ontario Superior Court of Justice over a civil conspiracy to improperly acquire the car for resale. The lawsuit seeks $750,000 U.S. in damages for misrepresentation and breach of contract, the revocation of the original sale deed, the blocking of any resale or transfer of the GT, as well as attorney fees. Both a Ford spokesperson as well as a downtown Ford general sales manager, Tim Foster, would not comment on the pending litigation to Automotive News. The Drive also reached out to them, didn't get a response. Given that the first legally resold Ford GT got 3 times its sale price at auction, whoever gets this car, of course, is going to win, but it's going to be a long and winding road of litigation to get there. So what's weird about this is, generally speaking, in a transaction, you have a thing for sale, a widget, a car, what have you. And I'm going to sell it to you, and it's going to be a purchase contract, a sales contract, a purchase agreement, whatever you want to call it. Contract underlying that, and usually with cars that are in writing. There are things I could sell you, like these. I can sell you these without having anything in writing. Be nice if it mattered, but you don't need writing for everything. But automobiles, many states, and I'm assuming provinces of Canada, do require the sales contract be memorialized in writing. And especially because there's taxes involved, generally writing's a good idea. So Ford Motor Company is, without question, the people who manufacture the car. And they sell the car. Now, be honest, most automobile sales don't take place from Ford to the end user because of franchise laws. Remember that? We talked about those with the Tesla guys. But in essence here, Ford is handpicking the buyers, and I'm assuming they do the last bit of paperwork through a dealer so they don't run afoul of those laws we just talked about. But Ford handpicks the buyers and then says, we will sell this person a car. Everyone knows when you buy one of these cars, it comes with that condition, you cannot resell it for 2 years. Still a good deal, but you got to sit on it for 2 years. Now, there's an odd aspect to this story in that Ford says, we know who bought the car. This guy did. This guy says, I didn't buy the car. Somebody misused my name. And that's a strange one. So there is possibly some chicanery going on there. But the bigger question people always ask me, they say, Steve, once I buy it, isn't it mine? I can do anything I want with it. Well, no. Because the contract you signed is a legally binding document, which doesn't go away once you own the car. There can be terms and conditions on that contract that follow you as long as you have the car. For example, an as-is disclaimer might be on that document, and once you own the car, that as-is document still continues having power. So the idea that you agreed and you said, I'm buying the car and I promise I will not flip this car for 2 years. If you didn't want to agree to that term, don't buy the car. And they have every right to enforce that term. And so if Ford Motor Company sells the car to an end buyer and there might be a middleman in the, there, like I said, like a car dealer. And the buyer, if they sign this document, they're stuck with it. Now, the only possible loophole here is I don't know if there's any specifically different rules with respect to this in Canada. I'm not going to pretend to know Canadian law. But I can tell you that Canadian law on contracts, from what I understand, they got their contracts pretty much from where we did, which is the English common law. So I suspect they're very similar. So I'd be surprised if this is not enforceable in Canada. But I can tell you right now that if it's not, Ford will just simply stop selling these things in Canada. So one guy gets a good deal, but Ford can just stop and say, we would do it, but we can't enforce this clause. So it's in the best interest of everybody to let that clause get enforced, except for the one guy who wants to profit. The only question, of course, is who signed the document saying, I'm buying this car and I agree to these terms? Because if the guy whose name is on the documents didn't do that, then the sale would be null and void probably. Because this guy didn't sign the documents and the guy who took delivery didn't sign the documents, or if he did, he signed them fraudulent. There's a problem there. But if I had to bet money on this, I would suspect that Ford's going to win. And so what's really going on here, if you think about this, is it looks like somebody pulled a dipsy doodle here in an attempt to say, we got this car and we moved it through a whole bunch of entities now and we sold it, and you're not going to be able to figure out which entity it was that did it. Well, the bigger problem, of course, is that Ford is suing to get the car back, and they might be able to do that. Now, the problem, of course, is if the car is physically in Europe, it's going to get complicated. But one of the things you always wonder about when you look at litigation with a huge corporation is who's got more money, you or them. I don't need to tell you, but I will. Ford has a thing called the Office of General Counsel, OGC. OGC has several floors of buildings in Dearborn. I know guys who work there. And I can assure you that they've got more money to spend on lawyers, and they've got more lawyers than you can afford. So when it comes time to go to court, and a lot of times it is a battle as to who can outspend who, I wouldn't bet against Ford on that one, especially when they're in the right. They had a contract, and they said, if you want to buy this car, sign the contract that says you won't flip it for 2 years. That's enforceable. That's enforceable. So in America, it's enforceable. I suspect it's enforceable in Canada. The tricky part is what's going to happen if the car is in Europe? Can they actually drag it back? And if not, will Ford get a judgment against an entity that can actually be worked upon? So those are the bigger questions. But yeah, if you get lucky enough to get yourself on the list to get yourself a Ford GT, I would suggest that you just plunk down the money, drive it for a couple of years, and you want to flip it then, flip it then. It'll still be worth some money, okay? So I got to thank Cliff for passing the story along to me. And, of course, Steph Schrader, who wrote it. Steph is a wonderful writer about cars and especially racing and fast cars. So there you go. Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Restrictor plates are of the devil.